Good morning.
Good morning, Your Honor. Mike
Good morning, Your
Watson for plaintiff in the Lightfoot case. How are you?
Okay, I have a few matters on my calendar that we're going to need to work through this morning. Let me just see who all I've got here. First position is Ronald Lightfoot versus Red Diamond Realty. Who do I have here on behalf of Mr. Lightfoot?
Good morning, Your Honor. It's Mike Watson and Minerva Steele is here. Mike Smith is just going to be listening in for a while, and then our paralegal is Miss Lee is on as well.
Okay, thank you, sir.
Yes, ma'am.
And who do I have here on behalf of the defendant?
Michael Becker on behalf of Red Diamond Hospitality.
Okay. Thank you. And then the next position I have is Okmulgee Judicial Circuit Public Defender versus Omatayo Ali and Natalie Glazer. Who do I have in that matter?
Good morning, Your Honor. Tiffany Ellenberg for the plaintiffs, and John Smith is also on for the defendants, respondents.
Okay.
Good morning, Your Honor. And also from our office, Ms. Dowdle is here as well.
Okay. So, okay. And then who do I have in the Progressive Mountain versus Yellow King matter?
Good morning, Your Honor. Jennifer Pridgeon on behalf of Progressive Mountain, and my associate Margaret Mans is also on the call.
Okay. And who do I have here on behalf of the defendants slash claimants?
Your Honor, several of the respondents are in default.
Are in default.
Yeah, I will say respondents Lowe and Taylor, they've opposed our pending motion for summary judgment. I would have expected their counsel to be here, but I don't see them on the call so far.
Yep. And I was going to ask you, as I see it, I think everyone other, there are either motions for default or there is a pending motion for summary judgment as to everyone other than the personal injury claimants who are seeking the benefit of the insurance claim. Is that correct? Okay.
Yes.
Mr. Freehoff, can you check and see if we've heard from Ms. Simmons, who I have listed as counsel for the two remaining non-defaulted defendants who object to the motion for summary judgment? And then I think that's all I have for my 9 o'clock hour. So let me go back for a moment to the Ronald Lightfoot versus Red Diamond. So you guys argued a motion for sanctions and a motion for summary judgment against me some time ago. A motion for summary judgment, not against me, in front of me, some time ago. And I have not been in a position to get you guys a ruling. I have been working diligently to prepare an order on those issues. I do have one question that as I was looking through these issues, I realized I am less clear than I perhaps should be. And it's not substantive, it's more procedural, which is where does, I believe my understanding is that Mr. Korich was ultimately served but has defaulted. Is that correct?
Well, technically, he's not in default because Your Honor never issued an order directing that he filed an answer, but he has not filed an answer,
Okay.
and no one has filed an appearance on his behalf.
Okay. And what then of the Red Diamond Realty, who is the owner of the hotel? Is that right?
They own the property, but the coverage is for Red Diamond Hospitality, unless I'm mistaken, Mr. Becker.
That's my understanding as well. And I think procedurally, they might have been in default originally, but with the filing of an amended pleading to which no answer is required, they are effectively not anymore.
Right. And I guess what I'm trying to figure out is what does the court do with these two parties slash non-entities?
I think originally, Your Honor, I had pointed out in Red Diamond Hospitality's motion for summary judgment that, should the court base a decision on the exclusive remedy, that issue was jurisdictional and that the court would likely have an obligation to address that issue with all defendants. In between all of the briefing and the argument given on this matter and right now, I think it was in June of 26, the Court of Appeals changed the law on that and said it's not jurisdictional. As of a few days ago or a few weeks ago, I think that Court of Appeals case has petitioned for certiorari on that issue, as one might expect. So
Although, sorry, go ahead.
that may have been the wrap up of my thought, Judge. So we may be back to, if that's not one of the issues in the summary judgment motion, and it depends on the way that the court rules on everything, on all of those issues, then it would leave, theoretically, potentially summary judgment granted to Red Diamond Hospitality and the case still pending against Corich and Red Diamond Realty.
Thank you, Mr. Becker. Oh, I'm sorry.
Yeah,
All right.
no, that's the end of my thought. Sorry.
Mr. Watson?
I respectfully disagree. I don't think there's any change in the law. I think Crooks v. Six Flags just
Well, hang on,
clarified
guys.
the
I
law.
have spent a lot of time with Crooks in the last, say, week or so. And so I have my own opinion about what it means or doesn't mean, and I don't need you guys to argue to me what it does or doesn't mean. I'm going to take what Mr. Becker said with a grain of salt and assume, Mr. Watson, that you disagreed with him. So,
Okay, thank you, Your Honor.
but were you going to say anything else regarding the procedural posture of the case?
No, ma'am. I
Okay.
don't think so.
Okay. Here is the position that I find myself in, and the reason that I am asking those questions is, as I said, I have spent a good deal of time with this case in the last week or so, in the lead up to summary judgment, to the pretrial conference. And ultimately, I have started drafting an order that is going to grant summary judgment in favor of Red Diamond Hospitality. I believe that I'll be done with that order in the next, say, 3 to 4 days. And so you guys can undertake whatever action you wish to take. It is primarily a decision based on what I believe to be a lack of evidence of knowledge or foreseeability on the part of Red Diamond Hospitality. Secondarily, it is as to the exclusive remedy issue, but that's not the primary focus. I'm only providing a ruling. And given the certiorari petition as to Crooks and the fact that it might be considered an open issue, I'll decide what to do with that in my ruling. But that is ultimately going to be the order that I'm going to enter. And so what that means is I then need to figure out, and that's why I was asking those questions, is once I provide that order, I need some insight from the parties as to what then happens next. Because I believe that leaves Corich and Red Diamond Realty in this weird in-between that we have to figure out what to do with procedurally. And so that's sort of where I am. I know that's a big, it is a very definitive ruling for me to just plop on you at a pretrial conference. I recognize that. But y'all, I know that you have invested substantial time and energy in getting to this point, and I did not want the parties to continue to advance substantial resources and effort when I'm going to grant summary judgment, and y'all will probably want to put your efforts towards something else rather than preparation for trial, unless we figure out that we still need to go through some sort of trial relative to Mr. Corich and to Red Diamond Realty. And so that's going to be my ruling. I don't necessarily want to get into too much of the substance of it because I'm going to give you a written order in the next 2 to 3 days, 3 to 4 days. But I did want to let you know that that was going to be our ruling and just give you some general idea of what the basis of that ruling was going to be. Mr. Watson?
Your Honor, I think given that you're going to grant summary judgment as to Red Diamond Hospitality, I think that's directly appealable as opposed to having to file a cert. So
It is.
And no disrespect to the court, but you know, we don't agree, so we
Of course,
will
I fully expected that you would. That's
Well, I
why I
know
was
that,
trying to
but
figure out. I
no, I
like to tie
appreciate
things
it.
up in a nice bow if I can. And what I don't love is Mr. Corich and Red Diamond Realty hanging out there for us to not really do anything with while y'all go and take the real show right to the Court of Appeals and have them say if they think I got it wrong or not. Totally understand it.
Well,
No
it,
disrespect taken, Mr. Watson.
thank you, Your Honor. I mean, would the court consider staying the matter while it's on appeal?
I might. That might be the most reasonable and logical thing for the court to do. I just wanted to mention that because that is going to be
Yeah,
the ruling that I enter, that is an issue that will be hanging out there and we'll need to
yeah.
figure out what to do while the plaintiff pursues its appellate remedies.
Well, that would just knee-jerk reaction.
Yes, sir.
That would be our preference, would be to go ahead and let it go up on appeal, see what the Court of Appeals does, and obviously, if Crooks is up to Supreme Court, that could certainly impact it. But that would be our request. We'll go ahead and file a notice of appeal, you know, get the record, send it up, and then if we could just, at least at this point in time, stay the matter as to the other two defendants.
Understood. Thank you, Mr. Watson. Mr. Becker, any thoughts regarding that request or any other, any issues associated with that?
I can't speak for Red Diamond Realty or
Right.
Mr. Corich really. So these might perhaps just be my appellate and jurisdictional musings. But I think to the extent supersedias didn't automatically do exactly that, you know, that's what I would do. That's what I would be asking for if I was either of those two parties.
Okay. Well, that is what we will do. As I said, it is the 6th of August. I expect and hope that you will have a written order that will be entered by midweek next week, maybe sooner, because I do have a fairly good draft that I'm working with. But I do have to finalize it. And so, and given how closely I know it will be argued, I want to make sure and cross my T's and dot my I's. But in any event, that is going to be my ruling. And so unless there's anything else that the parties need from me, I was going to send you all on your way. And then you'll have my order in the next 3 to 4 days. Mr. Watson,
Nothing on,
anything else? Okay.
excuse me, Your Honor, I'm sorry. Nothing on behalf of plaintiff and
Mr. Becker.
Nothing on behalf of Red Diamond Hospitality. Thank you.
Okay. Thank you all. Have a good day.
we can
too.
be excused, Your Honor.
Yes, sir.
Thank you, ma'am.
Thank you, Judge.
Okay. Ms. Ellenberg and Mr. Smith. So here's the situation in which this case, so I ruled right at the outset on a TRO, I think, motion. I think I denied a motion to dismiss. I can't exactly remember the procedural posture, but the point was there was a particular legal issue that was being made regarding the relative authority of the parties to do what had been done. And the court entered an initial ruling on that. I think one of the parties asked for a certificate, which I declined because I wanted the case to be finalized in its entirety on a more thorough record so that the Court of Appeals could, or the Supreme Court could look at the factual, or excuse me, the legal issue and provide us with some guidance. What I have now, though, is a summary judgment motion that has not been responded to by the plaintiffs. The time for that has passed. I obviously the law is quite clear that you don't grant summary judgment by default, which I have no intention of doing. But I don't quite know where we are in terms of any intention by the supervisory panel, Ms. Ellenberg and your colleagues, to respond to the summary judgment motion. Because, I mean, let's face it, to my way of thinking, it's essentially the same legal issue. And that's sort of what I said originally is why don't we, instead of going up on a certificate, why don't we all agree that this is final and go? But then there was some discussion that no, there might be discovery we want to do. And I don't know. There's nothing in the record that indicates to me that any discovery has taken place, but that may be simply because the parties, I know it's a little some people file notices of various discovery actions and others don't, so that's fine. Ms. Ellenberg, what is the posture of the case as you understand it?
Well, thank you, Your Honor. Mr. Smith and I have talked and been in communication. And so in response to your initial inquiry regarding the motion for summary judgment, we do agree it's kind of the same issue as before. I believe it was yesterday, Mr. Smith filed a motion in limine that we have not responded to because we just got it yesterday. He and I discussed that perhaps to accelerate the case with this motion in limine that got filed yesterday, that we file a response to both the motion and for summary judgment and motion in limine next week, specifically by Tuesday, August the 11th. And Mr. Smith is, yes, I see him on there. I'm just making sure. We actually talked earlier this morning.
Great, I
So-
appreciate that.
And so, not trying to hijack the court, the
No,
court's
please,
direction.
when the parties work together, y'all actually get things done. So feel free, go ahead.
So, and Mr. Smith, jump right in there if I get off topic. So, or
I will.
leave something out. That we request that the court hold the motion for summary judgment in abeyance for right now. Your Honor will recall that this matter involves the interpretation of a statute. Mr. Smith and I have come up with the idea, while it would have been nice if we both had this idea a year ago, you know, sometimes it takes us a minute to get there. We would like to speak to the authors of the statute as well, who potentially could be witnesses identified in the case. But we would like the opportunity to track those individuals down and speak with them. The problem being, of course, the statute was drafted in 16 years ago. And a lot changes in everybody's lives in 16 years. So that's part of our hurdle there. But we believe that we should track them down, and that may help give us and provide some direction. So we would like the chance to do that. On that note, we would ask that if the court does set this down for a final hearing, respectfully, we ask the court consider specially setting it. The reason being, we're including some Superior Court judges, and coordinating all these attorney schedules is a logistical nightmare without a doubt. But I think it would need to be special set. And I didn't say this earlier, Mr. Smith, but it seems to me that sometimes Thursdays and Fridays are better than Mondays, because Mondays generally start a lot of trial weeks.
Sure.
I have no objection to, if it is special set, I have no objection to the day, Your Honor. End of the week's fine. If Your Honor sees fit to special set it. I do agree that our position would be that we would like it to be special set, if possible.
And we also agreed, Your Honor, with the court's permission, of course, that considering there are witnesses all over the state, that if a witness wanted to appear by Zoom with the court's permission, that we, Mr. Smith and I, do not object to that. It would be a final hearing. So I think we can do that by agreement with the court's approval.
Oh, you absolutely can. And I do a lot of stuff by Zoom. And certainly in this context, if you have witnesses from across the state, it would make a lot of sense for them to be able to just Zoom in, assuming that all the parties were in agreement. One thing that I still find myself struggling with, with what you're proposing procedurally makes complete sense. I don't have any issues with it in terms of trying to realistically address the issues and prepare the case. I think what I'm struggling with from a larger perspective, and maybe this is my own fault for not granting the certificate back then, but as I understand it, and what I encouraged or discouraged, I should say, the parties from getting into when we were at the TRO hearing is, I don't know that a lot of discussion by lawyers, judges, the panel about whether a particular person is or is not a good and effective public defender, and should or should not have been listed as someone who is possibly on a list to be appointed by Ms. Ali. I don't know that those facts are relevant, right? Because
We agree.
to me, ultimately, This is a legal issue as to whether or not Ms. Ali has the authority that she is asserting based on the actions that were taken by the Public Defender Council in only identifying one person on their list.
We agree, Your Honor. I think there are no issues of fact here. I think
Okay.
this is an issue of law for the court to decide, and it comes down to a very narrow, I think, issue of law.
And so to that point, I guess my question is, why not? What I expected would happen, truthfully, Ms. Ellenberg, is that the Ms. Ali's counsel, which they did, was going to file a summary judgment motion on basically the same issue. And then I was expecting a legal response from the plaintiffs, basically sort of rehashing some additional information, perhaps with a little bit more, affidavit driven information potentially. But that's what I was expecting. And then a ruling one way or the other that y'all could then take up directly. Is that, I guess I'm still struggling with why is it that you believe that depositions are, because let's face it, if it is a pure legal issue, why do we need to, it's y'all's case. You're the master of your own complaint, Ms. Ellenberg. And if you believe that's necessary, then we can have a conversation about it. But if it really is a legal issue, as I, at least at the outside, perceive it to be, then why do we want to take up the valuable time of all of the judges and lawyers whose time is much better spent in court and representing, indigent criminal defendants to argue about this?
We agree, Your Honor. Mr. Smith and I do agree it is an issue of law, not an issue of fact. And we agree there's basically two issues. One is a list of nominees with S in parentheses.
That's why I air quoted, because
Right.
that was the whole issue is if there's only one thing on it, is it a list?
Right. And so
and with regard to this particular statute, just so we're clear.
Yes, of course. Yeah.
And so is a list of nominees, does one constitute a list, is the first question. And the second question that Mr. Smith and I agreed is that can the director deviate from the list? Can she choose a name outside of the list?
Right. And as I understand it, my prior ruling and the party's argument where y'all diverge is that Ms. Ali's position is that one name is not a list of nominees within the meaning of the statute, and therefore the supervisory panel didn't do what it was supposed to do. And so Ms. Ali was authorized to reach out and appoint someone that she wanted to. And the supervisory panel's position is no, one name is a list. There's nothing in the statute that says it has to be more than one. In fact, I think, without benefit of looking at my order and haven't looked at it recently, but I think it's not less than, I think, or not more than 5 or something. There's some language about that. And so I guess my question is, rather than getting into depositions and tracking down legislators who, let's face it, the Court of Appeals and the Supreme Court remind us all the time that we're supposed to assume that the legislature said what it meant and meant what it said. And so generally, I'm not sure how much value or benefit we would get from asking legislators from 16 years ago what they meant 16 years ago. And I think Scalia even made the point that the problem with legislative history is that might be what the drafters intended, but that might not be what the 48 other people who voted for it believed it meant when they voted for it. And so I think there's some limitations there. But I think there's a nugget here of what you mentioned before, Ms. Ellenberg, which is I have not truthfully seen I saw a motion in limine come across. I have not seen what its substance was about. But it sounds as if there was some discussion between you and Mr. Smith about the plaintiffs responding substantively to both that motion and the summary judgment motion by next week. And then the court would be in a position to provide the parties with a legal ruling, which would be immediately directly appealable, I'm pretty sure. What are your thoughts on that, Mr. Smith?
Your Honor, let me go back just a minute, and I did hear everything you said. Thank you. I am fine. I think there'd be no objection to having Ms. Ellenberg respond to those two motions. The motion to eliminate was basically just to preclude other people from other circuits coming in to testify about this particular incident. Because I
Mhm.
think it's narrow to this particular incident that happened in March of
Yes, sir.
2025. That
Mhm.
was basically my motion to eliminate. As far as my motion for summary judgment, um, it, let me just be frank with the court. It was hastily written because I did not yet have discovery responses from Ms. Ellenberg, which I got after that.
Mhm.
And I did ask for an extension, Your Honor. Your Honor did not grant that, which is perfectly fine. But my idea
Well,
was if I had that extension, I was going to draft a more substantive motion for summary judgment.
and we can still revisit that issue. In all honesty, the reason that I had not is because, as I said, it did not appear to me from the record that there was ongoing discovery of any substantial nature, and because, right or wrong, I have perceived this to be a legal issue that wouldn't necessarily be driven by substantial discovery. I was like, meh. But if the parties are now in communication about what might be, I mean, here's the thing. If we are in agreement that it is a legal issue, then I think it behooves the parties and the court to let y'all properly brief those legal issues. And I'm happy to give you a little bit of time to do it. But I expect that you call it whatever procedural vehicle you want, but that ultimately what you guys are going to end up with is a ruling from this court one way or the other. And that is what will be taken up to the Court of Appeals, rather than engaging in a fact-finding mission. But I could be wrong, right? I might look at the summary judgment and be like, no, maybe there are some facts I need to understand, because obviously I'm aware there's a lot of personality issues and a lot of, if I recall correctly, arguments by Ms. Ali that the panel didn't conduct interviews or did conduct interviews and that sort of thing. And so those facts might become relevant. But what I had expected would occur is a summary judgment motion that would deal with that legal issue one direction or the other. If that's the
And
case, Mr. Smith, and I did give you some additional time, what kind of time do the parties think they need? Is there actually additional discovery, or are we really talking about trying to track down the legislators?
I don't believe well, given what Your Honor said, I may still try to just have a phone call with the one of the authors. I just got one name, and I just got that recently.
Mhm.
But I think that I believe Your Honor is moving towards is if the court would allow me to amend my motion for summary judgment and just give it a little more substance. It was very quickly written, and I can do that within 10 days, and then have Ms. Ellenberg respond within another 10 days.
Well, there's no
That
reason, we don't have to be in a rush, right? I don't mind giving you a reasonable amount of time. And so what I don't think you need to, because here's what Mr. Smith, what I'm probably going to do is, even though I am a stickler for deadlines and the deadline has passed, given that the parties are, working together to try and get, to properly frame this, what I think is an important legal issue, right? That will help not just the Okmulgee Judicial Circuit defender, but other circuits in the state. So if I tell you that whatever amended motion you file, I'm going to give the plaintiffs the standard 30 days to respond, how much time would you want to be able to properly put together the summary judgment that you want, sir?
14 days, Your Honor, 2 weeks.
Okay. Okay. So today is the 6th of August. And so 2 weeks from now would be the 20th. Excuse me. Yes, August would be the 20th of August. We'll call it the 21st, which is a Friday. And then Ms. Ellenberg, your clients would have the, statutory 30 days to respond to the summary judgment motion. Now, I have said a lot about what I think about y'all's case. Ultimately, it is your case. It is not my case. And so I think it makes sense for y'all to proceed this way, but if y'all are going to tell me that there is actual discovery you need to engage in and what you need is an amended scheduling order that gives you additional time to conduct discovery, then now is your chance to say that to me because that window is closed once this hearing is over.
We have what we need, Your Honor, from opposing counsel.
Yes, Your
Ellen?
Honor. I think the only thing that we would attach to a response or any motion would be affidavits. I don't think there's any other discovery we need to conduct.
Okay.
And the only thing I would say is maybe to reduce some of the paperwork or reading, if agreeable with Mr. Smith and obviously the court, then I will file a response to the initial summary judgment motion and the amended in one response.
Yeah, no, and I'm firmly of the opinion that once something is amended, that amendment subsumes the prior. And so what I expect you to do is just answer the amended. And to the extent there's something in the prior one that you feel the need to answer, you absolutely can respond to that. But I feel like that's going to be sufficient for you to respond. So
Really, no disagreement from us, Your Honor.
thank you, Mr. Smith. So, Mr. Smith, I think what we're left with is that the defendants are going to have until August the 21st to file an amended summary judgment motion. And then the plaintiffs will have 30 days from there to file a response. And I think that will be the 20th, assuming that is a weekday, and it is not. So the plaintiffs will have until September the 21st to file a response. And then we will, see if that gets us to a legal ruling. And if it does, then you guys can take it up on appeal and see what the Court of Appeals says. Anything else you guys need from me, Ms. Ellenberg or Mr. Smith?
Your Honor, just going back to one issue brought up earlier, I don't know if it even matters now, but Ms. Ellenberg and I did consent to dropping Ms. Glazer as a party by consent. If we get you a consent order, would you entertain that?
Of course, happy to.
Okay, and I will get that to you. We will get it to you within the week.
Okay.
And Your Honor, on that same topic, if this did go to a hearing, the only thing, and I'm sure Mr. Smith will have that included in the order, is that she would still be available as a witness without further subpoena.
Absolutely.
Okay. Sounds like you guys are being reasonable. I always love that when lawyers are being reasonable. Thank you.
Thank you, Your Honor.
Anything else, Ms. Ellenberg?
Not on behalf of the plaintiff, Your Honor.
Anything else, Mr. Smith?
No, Your Honor. Thank you for helping us with this. That was much appreciated.
Well, thank you very much for, as I said, for your civility and professionalism in terms of working through these issues. I will look for your amended motion for summary judgment and the plaintiff's response, and then we'll move forward from there in late September. Okay?
That's great.
Thank you all. Have a good day.
Your Honor, just for a quick matter of clarification, if we're not scheduling it for a hearing, do you want us also to file to the motion and respond of a response to the motion in limine? Or
that's entirely your decision. It is technically a pending motion. It is not a motion that I'm going to rule on the briefs. It is a motion that I would rule on if and when. The only thing I would say is sometimes I get motions in limine related to what I can or shouldn't consider on summary judgment. So if it has anything to do with the summary judgment motion, then it would be your strategy and tactical decision whether to respond or not.
Yes, Your Honor. I just wanted to make sure. Thank you.
Excellent. Thank you both. Have a good day.
You too.
Thank you. Bye.
Bye-bye.
Ms. Pridgeon.
Yes, good morning, Your Honor.
Thank you for your patience. And who do I have here?
Good morning, Judge. Alex Perwich on behalf of Mrs. Lowe and Mr. Taylor. And
Yes.
by apologizing first to the court and to the other attorneys on this case, I apologize for the confusion and the failure to appear at the start time.
No, don't worry about it. As you saw, I had my hands full with some other things. So better late than never is.
I appreciate the grace. Seriously.
Definitely fine. Just one quick second. And before we get started, can you guys give me like 2 minutes to get a fresh cup of coffee and then I'll be right back with you. Thanks. Thank you. Sorry for that delay, but always better to have a fully caffeinated judge. Okay. So where this case is, obviously there is a summary judgment motion pending. It just became ripe recently with a response by Ms. Lowe and Mr. Taylor, and the court will deal with that in due course. It is my goal to, because technically you are set on a trial calendar, right? So I need to figure out if I'm going to grant that motion before we figure out what resources you guys need to devote. Beyond that, Ms. Pridgeon, do we have any outstanding? I believe there are some defendants who are fully in default well, let me say this, other than Ms. Lowe and Mr. Taylor, I thought that all of the defendants were technically in default, and a couple of them, the court had already entered final default judgment, but not for all of them. Is that accurate?
That is correct. The court has entered default on Keon Butler and I believe Deborah Butler and
Edward King was the one still outstanding.
and Yellow King, and then yes, correct, Your Honor.
Okay. And I have a pending motion for default as to Edward King that is ripe. And it does appear that Mr. King is in default. I think the primary issue with a case like this is that absent a granting of summary judgment, in order to determine the nature of, sometimes I refrain from entering a final default judgment as to those defendants because the nature of this case requires me to make declarations that have an effect on larger groups of people than just these defaulted defendants.
Understood, Your Honor. And I agree with that. And I think Mr. Purwich filed a brief on behalf of his clients. I think it was kind of styled as an opposition to the motion for default, but I think he was making the same point, was that
Exactly.
Yeah,
basically
agreed.
his clients aren't bound by any default findings. And I
Right.
don't make any other contention. I agree with that.
Okay.
Yeah, that's correct, Jennifer. I mean, and we don't have any argument on the technicality, like, the default or anything like that. And, really, I think the issue here is the lack of participation from the actual insureds, right? And that's been the ongoing issue in the underlying civil suit as well. So that's kind of thrown a wrench into how we're, on at least for Mr. Taylor and Mrs. Lowe, is how we're handling it. So, in the meantime, just so everyone's aware, we've made a concerted effort to have our investigator try and locate these individuals, because I would surmise that their participation would alter the trajectory. That being the case, though, I understand the judge is in a hard position here. I don't know how you would be able to overturn Ms. Pridgeon's argument here. I think obviously under the circumstances right now and the legal authority that we'd be, dealing with, it's hard for us on this side, Mr. Taylor, Mrs. Lowe, to have any viable argument other than saying, hey, this is unfair because the insureds are the ones not participating, blah, blah, blah. But, so I know everyone knows that's the situation, but.
Yep. So what, other than the default for Mr. King, where is this case procedurally other than the default for Mr. King and y'all waiting for me to give you a ruling on summary judgment? Ms. Pridgeon?
I mean, I think that's where we are. I will say, Your Honor, I intend to file a reply brief, a very short one, in
Sure.
support of our motion for summary judgment. I think they filed their response on the 27th. I would like to have that done.
It was docketed on the 28th. Sometimes that matters, sometimes it doesn't, but it's technically in the docket as of the 28th.
Right. I will say I think technically that makes it untimely. I would rather focus on the substantive issues than the timeliness of the response, but that's obviously in Your Honor's discretion. But I would try to have reply briefs filed within 14 days. So I would hope to have it filed early next week. And then I think it's ripe for either a hearing or order just based on the briefs, however Your Honor wants to handle that. And then, obviously, from Progressive standpoint, we would think that motion would be dispositive of the case, kind of in conjunction with the other default orders. But that's obviously at your honor's discretion. And obviously Mr. Purwich would respectfully disagree with that.
Of course. And so I don't know if you have already requested, and if you had, my standing order requires a request to file a reply. I'm happy to grant it to you. I'll consider this your request. So it's
Okay.
perfectly fine with me for you to file a reply. And Mr. Freehoff, probably make a note, because when we get it, we're going to be like, did we say she could file a reply? I don't want to forget. But in any event, what I will do is wait for the reply brief and endeavor to provide you with a ruling on it as quickly as I can. Once I have the reply brief, I will be in a position. I don't believe there is a request for hearing there, so you're not entitled to one, but sometimes, I might get into the weeds of the motion and decide, what, it would be helpful for me to have the parties sort of talk me through this a little bit. And then what I would envision is once I determine what my ruling is going to be on the summary judgment, then I would at the same time finalize a formal default judgment as to Mr. King, who is, again, irretrievably in default at this point. And so it is just a matter of entering that order once the time is right. Anything else that y'all need from me other than that you can be assured that I will not be calling you in for trial in 3 weeks on this matter. It is my goal to provide you with a ruling by about then. And I will tell you, sometimes I write my own orders. Sometimes I say, hey, parties, write me an order, and then I'll edit it. And so just so you know what to expect, it may be that I send you guys an email and say, I'm going to rule in favor of X, and say, X, please write me a proposed order that grants that motion or denies that motion based on what my ruling is going to be. So sometimes I just write my own orders, and I'll let you know which one it's going to be, one way or the other.
Understood. Thank you, Your Honor.
Anything that you guys need from me. I will say that from a placeholder perspective, just to keep the matter on the front burner, it is likely that it will just be rolled over to the next trial calendar. So that is a way for me to stay on top of it, to make sure that it doesn't just sit there after discovery's closed for, a year waiting on me to rule on a summary judgment motion, so y'all can decide if you need to go to trial or not. And so when you get that and see it, just stay in touch with Mr. Freehoff, because he will easily be in a position to say, no, you don't have to appear for the pretrial conference. The judge is, is just keeping that there so that she knows she needs to rule on that summary judgment motion.
Understood. Thank you for that heads up, Your Honor. My
Thank you.
claims rep will like that explanation. So.
Okay, excellent. Anything else that you guys need from me, Ms. Pridgeon?
I don't think so, Your Honor, not on behalf of Progressive.
Mr. Purwich?
Nothing, Judge. Thank you.
Okay, excellent. Well, everybody have a good day, and I will see you by email, and I will get you an order as quickly as I can. Thank you all.
Thanks, Judge.
Thank you, Your
too.
Honor.
Bye-bye. Good morning, Mr. Bennett. How are you doing, sir?
I'm good. How about you?
I'm doing okay, thank you. I wanted to um so I have you down for a hearing today, a final hearing to review the appeal that you filed, appealing a board determination by the Department of Labor. And I am sorry to tell you that there's nothing I can review today, and here's why. So the way this is supposed to work is when you file your petition for judicial review, you are obligated to serve the Department of Labor by certified mail and to certify that you have done so. And you have to do so within 5 days. Now, you might have done so, I don't know, because there's not any documentation in the file that you did so. And more importantly, I don't actually have the board's record. So there's nothing for me to review because the only role I serve in a review of this type is to review the board's record and then hear argument from you. And so, when you filed your petition back in June, did you serve or provide notice to the Georgia Department of Labor that you had filed it?
The only thing I did was fill out like the summons sheet that I found, and I just filed that on the website. I didn't know that I needed to actually like I guess I thought that would be handled by the courts, but I guess I was wrong in thinking that.
Yeah, so sir, here is all I can do at this point. And I do apologize that you appeared today and did not have this information sooner. What typically happens when we get a case like this where it looks like the board did not receive notice, and so I don't have the file to review, is we typically will enter an order to show due diligence of what efforts you made to serve the board. And I can enter that order, and then you can try to provide me with documentation that you have provided notice to the board. But because there is a time limitation about serving the board, right? It's hang on just one second. Let me tell you specifically. OCGA 34-8-223 requires that the petition be served upon the commissioner within 30 days from the date of filing. And then within 30 days after service of the petition, they have to provide us with the notification. And this indicates that you can serve it by hand delivery, certified mail, overnight delivery, or any other manner that's allowed by law. But it doesn't seem like you have done that. And so I don't know that I would be able to give you any relief, but I can, if you believe it would be helpful and you might be able to attempt to confirm that they have service or that they had notice, I can enter that sort of standard order that we enter that says we're going to dismiss if you don't provide us with proof of service. And then you can attempt to provide us with proof of service. But that's sort of the posture that we're in right now. Do you understand that, Mr. Bennett?
Somewhat. So if I go ahead and serve them now, is it too late for that? Or is that something I can do now?
So the statute says you have to do it within 30 days. I can't, that issue is not in front of me. So I can't tell you that it would be late or it wouldn't be late. I can tell you that if you did it now, it may be that the Department of Labor comes forward and says, this is too late. He didn't serve us within the time period. I don't know the answer to that because that issue is not in front of me. But that's what I would expect the Department of Labor's answer to be, if that makes sense.
Yeah, I'm sure. So I'm not sure what I should do from here. Is it even worth my time to even serve them? Or is that just a waste of effort, do you think?
Well, I can't give you legal advice.
Right.
And I will say that I feel like you might have more time to, if I just enter an order that says I'm going to dismiss unless you provide me with proof that you got service and due diligence to have done so in the time period. then at least that would give you a little bit of time to think about it, maybe do some research if it's worth your time or not, instead of putting you on the spot right now. And so that's what I would say, let me do. And then that way you would at least have some time to think about it and decide how you want to proceed. Is that okay with you, Mr. Bennett? Mr. Bennett, are you there? Mr. Freehoff, can you hear me? Or am I the one that's frozen or are you frozen?
No, everything's working on our end.
Okay. I'm gonna sit tight and wait for see if Mr. Bennett is able to reconnect. But as I was
You are frozen now, Judge.
yeah, I know, I don't know why.
Oh, you're back. You're back.
I am going to I'm gonna sit tight for a minute, see if he rejoins, but as I mentioned, I am
Yeah, I'm going to do the standard notice of intent and give him probably to the end of the month, but hopefully he can get his answers on what he.
I will say